Hi, this is Samantha Allen from DEF News Today, providing political news 24/7. I'm outside the U.S. Supreme Court, where they'll be debating Baker versus Carr. This case started over a year ago, and we have the plaintiff, Charles Baker, mayor of Memphis, Tennessee, with us here today.
Hello, my name is Charles Baker, and I'm here at the United States Supreme Court. Finally, with this case that I've been pushing for a very, very long time. I'm very excited to be here.
So, can you explain your story from the beginning?
Well, sure, Sam. The Tennessee Constitution requires that the legislative districts be redrawn every 10 years according to the federal census to provide for districts of substantially equal population. But in my state, there hasn't been a redistricting since 1901. That's 61 years. Because of this, my district has grown 10 times as large and as numerous as the rural districts. That's just not fair. We need an equal vote. And I feel that it's against the 14th Amendment, which says voters have an equal protection of the law.
So you sued Joe Carr, the Secretary of State of Tennessee?
I sure did. Even though that the state legislative sets the district lines through ex officio, he is the person who's ultimately responsible for the conduct of elections in the state and the publication of district maps.
So you went to the state court?
Yes, but the state of Tennessee argued that the legislative districts were political questions, not judicial. But really, they just didn't want to enter the political thicket. Justice Felix Frankfurter believed that the relief for legislative malapportionment has to be won through the political process.
So now you're here.
Yes, I'm very excited to be here at the United States Supreme Court.
All right, great. Let's head on in a behind-the-scenes look at the opinions of the justices.
What is your case, Mr. Baker?
I, Charles Baker, sued Joe Carr, the Secretary of State of Tennessee, for ignoring his duties and letting the overall well-being of our state fall. Also, the current voting districts drawn produces unequal political representation. This violates the 14th Amendment Equal Protection Clause. The amendment reads that no state shall deny to any person within its jurisdiction the equal protection under the laws. Equal protection means that all persons or groups of persons in similar situations must be treated the same under the laws. Persons living in Tennessee are all in the similar situation of being Tennessee residents. Therefore, they should be treated equally under apportionment law by being equally represented in legislative bodies. I am sure you are familiar with this.
I am a Supreme Court Justice after all, Mr. Baker. Mr. Carr, do you have a rebuttal?
This is too much. This is too big of an issue for our state to deal with. This problem belongs in the federal court, not in the Supreme Court.
Mr. Baker, have you made any attempt in resolving this case with another court?
Yes, I have. The district court dismissed my case with the familiar reasoning that my complaint was a political question, which the courts have no authority to answer.
Do you have anything else you would like to add, Mr. Baker?
I believe the defendant, Mr. Carr, is guilty of being reluctant towards his job and towards his duties to our state. He just does not want to deal with these problems that have been placed before him, as he does not want to enter the political thicket.
Mr. Carr, do you agree with these accusations you have been accused of?
I hold my opinion.
We will discuss the evidence presented before us. Hello, I, Justice William J. Brennan, Jr., have written the majority opinion. I believe the plaintiff's constitutional right to have their votes count fairly gave them the necessary legal interest to bring the lawsuit. The case does not involve a political question that presents judicial review. A court could determine the constitutionality of a state's apportionment decisions without interfering with the legislator's political judgments. The case will be returned to the federal court. My fellow Justice William O. Douglas wrote a concurring opinion. He declared that if a vote no longer has the full constitutional value of his right to vote, and the legislative branch fails to take appropriate restorative action, the doors of the courts must be open to him. My fellow Justice John Harlan II wrote a dissenting opinion arguing that the federal Equal Protection Clause does not prevent a state from choosing any electoral legislative structure it thinks best suited to the interests, temper, and customs of its people. If a state chose to distribute electoral strength among geographical units rather than according to a census of population, he says that choice is a rational decision of policy entitled to equal respect from its core.
Well, there you have it. In a 6-2 ruling, the Supreme Court holds that the federal courts have the right to determine the constitutionality of a state's voting district.